Two more topics that we need to go through as time runs out. Shame of sham hate speech prosecutions as culprits walk free. They say the Director of Public Prosecutions, Nurdin Haji, was compelled to urge police to hurriedly arrest politicians spewing hate speech. Shows how difficult it is to tackle the crime. Senior counsel, you could start us off on this one. How difficult is it to prosecute this hate speech issue? Because always, anytime it comes up, there's always a statement that it was taken out of context. And there are those who also argue that the moment a statement is made, there's a difference between what is said and what is heard by the people. Why is it so difficult to prosecute this?
I think if you look at the framework, the legal framework under the National Cohesion and Integration Act, and of course the initial National Accord and Reconciliation Act, and what we have as offenses under Section 66A of the Penal Code. And of course, I'm sure the Mudama case, I've seen it cited here, is one of the cases that have been cited where the High Court declined to allow proceedings against Mheshimiwa Mudama to go on because of the media interference with the process, and the court found that he could not get a fair trial. Now, 2 points linger in this report. One, the role given to the national NCIC, the National Commission on Integration, National Cohesion and Integration Commission, specifically the powers that it enjoys under Section 13, give it powers to investigate and to make certain recommendations. Usually, this commission, the NCIC, now chaired by Reverend Professor Kobia, does endless investigations. That's number one. So there's a weak framework for investigations by NCIC. When the DPP takes over its role, because the Act itself prescribes specific offenses, now you find that, again, investigations take long, or when individuals are charged before court, they bring all sorts of defenses and lengthen trials. And then constitutional petitions are filed challenging the charges filed before court. I think that is why we have never really seen a conviction. Remember, the conviction under the NCIC Act is a fine of up to 1 million shillings and imprisonment of up to 3 years. But we have never seen a politician get a conviction through proceedings in court. I think likely because NCIC has been a talking house for too long a time. They always speak, they back, but there's a little action. But also, the investigators are to blame. If you do not present a watertight case, a properly investigated case to court, the case will obviously be lost, because the tenets of that case will be tested at trial by counsel appearing for the accused persons.
Halole, what is your take on this? And I did not hear you outrightly condemn what was mentioned by Mithika Linturi.
The Deputy President spoke on behalf of the membership of UDA, and we all agreed with him. What I would like Professor Tomo Janda to tell people on this issue is that there is a higher standard contained in the Constitution as opposed to what the Act attempts to achieve. What do I mean? The Constitution provides for freedom of speech and freedom of expression. Now, the Act, aware of that particular provision by the Constitution, wants to manage what some people would call fair comment and what others would call an honest comment. And because the Constitution supersedes acts of Parliament, I think Kenyans are going to wait for a long, long time before they see those convictions. An even longer time, because, Professor, welcome to the world of politics. Tomorrow it will be you in the dock. What is happening now is an attempt to weaponize that act so as to manage people who operate politically outside the so-called deep state and system. So if you are within the same formation with the deep state and the system, that weapon is not unleashed on you. Professor, are you aware that the former Prime Minister, Governor Taming, Junet Mohammed, Babu Wino, and others have been spewing hate speech, and nothing has been done against them simply because they are in the right formation?
And you can substantiate this because you can substantiate this on your own.
Come again?
You can substantiate all those accusations that you're making.
If you are kind the way sometimes you normally are to me, you would play the clips of those people the way you normally play mine here in this sitting. And then Kenyans would judge for themselves whether I'm saying something which is truthful or not. But you don't have to, because we don't come to this studio to put you on your defense. We come to this studio to discuss an idea. What I am refusing is that much as we are against perpetration of hate speech, it should not be used as a weapon to gag members of parliament and politicians who are not part of the formation of the succession plan. That I am against. Then secondly, we should also allow the courts, and Prof knows that the courts of this country are able to sort out this. We should allow them on every case to be able to make a determination of whether it was an honest comment, whether it was a fair comment. Politicians are not going to stop talking. They'll continue talking.
Okay. Well, Matangi, I see the one hate speech, has it been weaponized?
Probably, Trevor, you would start from where you are earlier on whether have we been serious as a country in meeting out the consequences, providing an elaborate process that will ensure that hate speech is a crime that is prosecutable and prosecuted, and consequences can be seen. I think that's where we should start. And first, I would say unequivocally that I think we got it wrong from the first time when we had the first commission, the NCIC commission. Because if you remember from all those days from the first commission during Kaparo's time, we have Kobia, there is no history. And you know, people tend to behave within what they perceive would be the consequences of certain actions. And that is why you find that if you do not apply penalty in law as is subscribed, then people will ultimately ignore that law and treat it with jest. And that's why I think in the first place we got it wrong from when we had the first NCIC. If the first few victims, and I don't know, when you look at the newspaper there, Trevor, on that page 7, you can see what they're saying about the first, some of those incitement cases, like the one that against Mudama. They said it was dropped because a court itself said or declared that there is a part of the penal code that is unconstitutional, so they dropped that. But you can look at even the one that's even more interesting is the one that was against the 6 members of parliament, that they were acquitted and discharged, and it was thrown out on grounds of the translation, that what they said when translated in Kiswahili would not necessarily amount to what it meant in English. And you ask yourself, are we serious? I would say this, in my view, if you want to look at it the way it should be looked at, Trevor. When you are prosecuting incitement charges or an incitement case, what mostly is our undoing is we focus on the person who has uttered those utterances, other than focusing on the possible consequences and what those who would be victims. Because in the first place, it's clear for people to understand. The reason we have this law and that provision and the commission is to protect the would-be victims of the consequences of those utterances. You know, and if you want to look probably around and see what I mean by that, remember the case that was with one of the French newspapers. Remember that time? And I think that newspaper ran some caricatures and some photos of the Prophet Muhammad doing something. And then an Islamic group went to that newspaper and slaughtered people in there, the editors and whatever. And that, those are the consequences of an incitement like that. In our case, we have got, you know, vivid images of what has happened when utterances were made that brewed and cooked in the minds of Kenyans for a long time until they exploded in 2007.
Yeah.
And Kenyans killed each other. And so, but because we have a short memory, and the immediate political expediency and correctness is our preoccupation, you'll find that when, for example, Boni Harwale is on the dock, it will quickly degenerate into a discussion as to how much the formation he is in will have to lose if he is not there, who and who within that formation can go and bail him out, and all these kind of things. And if indeed if he was prosecuted and jailed, would it tilt or shake the current status quo? You know, a lot of considerations, not remembering that you have Kenyans out there who do not have the power. And I've just used Boni Harwale as an example. It's not that there's nothing he said, but I'm saying as a politician, there will be no consideration as to imagine all those thousands or millions of Kenyans who are helpless, who are powerless, but who would be then victims of those utterances. And I think that's why we get it wrong. And if this would jolt the psyche and the thinking of the NCIC, they should start looking at things differently. Because if we are so quick to forget how this city looked like in 2007, Trevor, I believe you are still in this city then, you could not cross from here to the city center and onto the other side. It would be taking a life gamble with yourself. So I believe as leaders, as political leaders, people must be brought to bear. I don't think that at any one time there is a license that should be perceived to be given to people to just say anything. And once we start there, I believe that we would be getting somewhere as a country. Otherwise, if we leave it this way and the past that we've had, things can really get very, very bad.
So, Sion, how can this be rectified without finger pointing that so and so also said it? How come they've not been prosecuted? Said that so and so said it earlier than me. How can this be solved?
I don't think it is right to engage in selective justice, application of justice, for purposes of convenience to win a political score. We should not wake up now to the rule, to existence of the rule of law. And I think the cardinal principle here, and the fact in this country, is that the executive has abdicated its responsibility of ensuring that there is enforcement of the rule of law. This is a country that has the best legislation, the best laws in every way. But the culture of violating existing laws is being abated. And when you look at the executive and the state officers who defy even court rulings, court judgments, it's essentially anarchy. So the precedence of anarchy has been set by the government itself that is now seeking to prosecute certain individuals. And I think this is where the next president should be able to begin from. And we were dealing with the Saudi cases of workers who were taken to Saudi Arabia. And we could see the culture in Saudi Arabia, the law is law. And in fact, the constitution of Saudi Arabia is Quran. And anybody fears the rule of law. You mention the law and everybody shudders and fears the rule of law. But here in Kenya, we have a culture where we don't respect the rule of law. We even don't respect the constitution. And it's promoted by the executive. And I remember when Kibaki was elected, he said, we shall promote the rule of law and constitutional order. And to a very large extent, that was executed. The hallmark of Jubilee for the last 9 years is violation of the rule of law. and adulteration of the independence of the judiciary.
Yeah.
And therefore, this matter of Mintika Linthuri, which is triggering, should now take the entire country and all the presidential candidates about promoting the rule of law and respect of court judgments, and that will largely bring order in the country.
Right.
And this is where we have a problem. In fact, the problem of this country is not even the economy, it is not the it is consistency in respecting and enforcing constitutional order and the rule of law and respect of judiciary.
Right.
And for the matter, the flip-flop of Honorable Mintika Linthuri in terms of national cohesion is just one item among many components of respect of the rule of law. And so far, Mintika Linthuri has apologized and withdrawn. It is good to apologize and withdraw. And UDA party leader has made it very clearly, and a warning has been sounded to everyone. We must choose our words and sanitize our politics so that we don't create tension. And this is in line with Vision 2030, the political pillar of Vision 2030, which is running, that we must promote our politics to be issue-based and sanitize it from all this. So I would want to believe, and I can assure Kenyans, that UDA will be very decent. UDA membership and the leaders will be speaking everywhere. We shall choose our words, and we shall avoid statements that can bring tension, and statements that have been made in the past are regrettable. And for the matter of Linthuri, since it is in court, it will be a matter of our judicial system to prove. And I can assure you, he will be absolutely vindicated. So we want to believe as we head to 2022, we will play decent politics, choose decent statements, and promote politics of issues, and more importantly, we focus on what will improve the quality of the livelihood. But the rule of law, the rule of law and constitutional order is what has violation of the same, is what has prevailed during the Jubilee era.
All right, gentlemen, a lot of things have happened during this season that we are in a holiday season.